All right, good morning, everybody. Thanks for joining us. We're going to go ahead and get started. Welcome to Dealing with Debt Collectors. We're so pleased to have you all with us here today, and thank you to Becky and Julia for joining us. My apologies for my dog barking in the background. All right, so today we're going to cover a few things. We're going to be talking about how we can help our clients or community members, but also hopefully information that you can use for yourself as well. Understanding our rights in dealing with collections agencies and what that collections process is. Understanding those rights related to a credit report, including challenging errors and the new rules around what can and can't be reported. There's been lots of changes over the last couple of years, so we're going to talk some more about that. Prioritizing what debt to pay when money is tight. That's always tricky. So we'll be thinking through what the consequences are for not paying certain debts and also what some of the other options might be for folks. And medical debt. We're going to talk about the changes that are happening and what medical debts are reported on credit reports. There's been some big changes in the last couple of months that the credit bureaus have put out. And also there are changes coming to the charity care laws in Washington state. And so we're going to learn more about those as well. So hopefully you are in the right place, and thanks so much for joining us. All right, so before I hand it over to Julia and Becky, I just want to take a moment to share a little bit about the Financial Empowerment Network. For those of you who are new to our community, the Financial Empowerment Network envisions communities where low and moderate income individuals and families are able to achieve financial well-being. And we do that through partnerships and relationships. So we do not provide direct service. We work with providers across sectors who are working on financial wellness issues like all of you. So I like to say we're the financial educators of the financial educators. We have two main initiatives. The first is financial empowerment integration. And for the sake of time, I'm just going to mention a couple of things here. First, we offer free monthly workshops, which are all virtual. So we've done 4 so far this year. And our next workshop is June 21st at 10 a.m. and it's on cryptocurrency and digital wallets, provided by Brian Doerr of the Washington State Employees Credit Union. I will drop a link to register in the chat, and also a link to our website where we list both our past events and our upcoming events. So if you're looking for more information, you can find it there. Second, this spring, we have just launched our Financial Coaches Network. So this is an initiative that's co-chaired by Donna O'Connor of HopeLink and Barbara Maxwell of Blue Mountain Action Council. And we've got a fantastic steering committee that's helping us shape the work. The Financial Coaches Network meets the 4th Wednesday of each month from 2 to 3:30. So please save the date for May 25th. And if you'd like to be added to those announcements, drop your email in the chat and I will make sure that you are added to that list and get those announcements. The thing to know about that is your title does not have to be financial coach to participate. It's really for anybody who's working with clients and community members and having financial conversations with them. So don't feel like you need to be credentialed or somehow official to participate. It's open to anybody. And then the other side of our work is Bank On. And I want to make sure folks are familiar with Bank On. So Bank On is a national initiative that was developed to meet the needs of folks who are or underbanked and to get them connected to safe, affordable, and functional accounts. So the CFE Fund developed this national certification that financial institutions can obtain by offering an account that meets their set of standards. So the standards were really created with consumers in mind to ensure that the accounts are safe, affordable, and functional for folks with troubled or limited banking experience. So the features of the accounts include things like low opening deposit, low or no monthly fees, low or no minimum balance requirements, and then the best feature, in my opinion, is no overdraft charges. So nationally, Bank On is very focused on getting community members connected to checking accounts. But our goal with Bank On Washington is a little bit broader than that. It's really about ensuring community members have access to safe, affordable, accessible financial services across the spectrum of community needs. So we really want to focus on reducing the cost for folks to manage their money in all the ways that people need to manage their money. So for some folks, that means a checking account, but not for everybody. And we know that people need much more than a checking account. They also need access to credit building products, to payday loan alternatives, to capital to start a business, or to mortgage loans. So we are really trying to think broadly about how to meet the needs of folks that are using high cost, potentially exploitative financial services. So across the country, there are now 200 bank-on certified accounts, including 11 that are here in Washington state. And our role at the network is twofold. So we work with financial institutions towards offering bank-on certified accounts. And we work to ensure that community members are aware that these low-cost financial product options exist. So if you work for a financial institution that does not offer a certified account and you're interested in exploring the process, please reach out. I'd love to talk. Or if you have clients that could benefit from access to an account, please check out our Bank on Washington website, or let me know if you'd like to connect with a financial institution. I'm happy to help make those connections. The last thing I'll say about Bank on Washington is that we convene folks from across the state a few times each year. We do some smaller coffee hour events, and then we have an annual forum each fall. This year's forum will be in person in Yakima, and we're really excited about the opportunity to really have these conversations around what financial wellness means for the most marginalized and excluded communities across the state. You can catch Bank on Washington coming soon at the Washington Asset Building Coalition Conference next week in Tacoma. So there we'll be talking about some creative solutions to meeting the financial needs of communities and highlighting a couple of partners, Community Credit Lab and Express Credit Union. So I'm sure Ryan has already put it in the chat, but I've missed everything that's going by in the chat, but I will drop the link again. So we'd love to see you there and meet in person. It's in person in Tacoma, and it'd be lovely to meet folks. Okay, the last thing is there's lots of ways to connect with us. If you would like to stay updated on what the network's doing, you can follow us on LinkedIn or Facebook. We post workshops and events there, articles, but also I love to share member announcements. So if you want us to promote some of the work that you're doing, please reach out to me and I'm happy to share it both on social media, but also in our newsletter. Oh my goodness. All right. And so with that, let's turn to the reason that we're actually here today. And I want to introduce Julia and Becky. Thank you, both of you, for agreeing to share this important information with us. Julia Kellison is an attorney with Northwest Justice Project. Her consumer practice includes challenging debt collection abuses involving medical debt, garnishments, and predatory lending in student loans and auto sales. Julia is on the executive committee of the Washington State Bar Association's Antitrust, Consumer Protection, and Unfair Business section. She is a longtime partner in this work with the Financial Empowerment Network. Thank you, Julia. Hold on just one moment.
Thanks for having me.
All right. And Becky is the Director of Strategic Initiatives at American Financial Solutions. She also serves on the board of directors for the Financial Empowerment Network. Becky has over 25 years of experience in training and education development in nonprofits. And over the last 14 years, Becky has specialized in developing and presenting financial education and is certified as a financial educator through the National Foundation for Credit Counseling. She presents classes for community agencies, private employers, local community colleges, and universities. And she is an expert advisor for media outlets such as US News and World Report, ABC, CBS, and Money Magazine. Thank you, Becky, for sharing your expertise with us today. And I will turn it over to the two of you. Thank you.
Awesome, thank you. I am happy to be here today. I'm going to share my screen and get us going. All right. Yeah, I guess I'll go ahead and get us going. And, as we go through today, please feel free if you have questions, you can drop them in the chat, let us know. we like to, be able to answer questions as we go through rather than waiting till the end of the presentation. And maybe if the information is coming, we can tell you, hold tight 1 second and we'll answer that in just a sec. I'm going to start us out today with some basic, really just kind of vocabulary, just so that we're all on the same page as we go through today and talk. But when we talk about an original creditor, we're really talking about the first person, the original company, business, organization, agency, or service that loaned someone money or that they had an account with. When we're talking about in-house collections, then we're still talking about that original creditor. So again, the first person or the first business or organization that someone owed money to. And then this is sometimes I see where people get tripped up is when an account shows as charged off. So what that means is that original creditor has said, you know what, we're not going to be able to collect this debt. So we are taking a loss, charging it off. And it's most likely that account is now going to a collection agency, which is that third party that now they are either purchasing or contracting with that creditor, purchasing the debt from or contracting with that creditor to collect that debt. And that original creditor has said, you know what, we're not going to be able to collect that money. I don't know, Julia, do you want to add anything to that?
Yeah, I would say, and many folks that I work with get confused by charged off, thinking, oh, great, I don't owe the debt anymore. So as Becky said, it's really that the original creditor has said, we're not going to collect it, but we're going to hand it off to you, debt collector. It doesn't mean that the debt is gone.
Right, exactly. So with that, we have some good news. I think it's good news. I'm taking it as good news right now with medical debt and credit reports. So as of July, medical debt, and this is through the credit bureau, so Equifax, Experian, and TransUnion have said that they're going to implement rules that say medical debt must be at least 1 year old before it can be placed on a credit report. And they're no longer going to report paid medical collections on a credit report. So those are two huge wins for consumers as well. So it gives them more time if there's an issue with a medical debt and, showing that that's paid or dealing with insurance. And again, if it is paid, it just won't show up on the credit report. And then coming up in early 2023, all three of the bureaus have agreed that any medical debt that is under $500 will no longer be reported on the credit report. So again, huge win for consumers, and we hope to see some great improvement in people's credit as these rules roll out. And then there's even better news from Julia.
Also, this past legislative session, our Attorney General with Representative Tara Simmons and spurred on by Oregon, heightening the levels of charity care eligibility coming July 1st for care received on or after July 1st. The charity care eligibility guidelines go way up. Right now, the threshold until this date, the threshold, if you're 100% or below of the federal poverty level, that's what gets you full coverage for by charity care at a Washington hospital. Many hospitals go above that, but that's the baseline that what hospitals have to provide. Coming July 1st, that floor goes up to 200% for every hospital, and they've divided it up into 2 tiers. So here on this slide, that tier 2, basically all hospitals have to provide at least free care for families and patients that are at or below 200% of the federal poverty level, with a 75% discount between 201 and 250% of FPL, 50% discount between 251 and 300% of FPL. Larger hospitals, those tier 1 hospitals at the top of the slide, have an even higher threshold and must provide free care up to 300% of the poverty level. with discounts of 75% between 301 and 350% of federal poverty level, and 50% discount between 351 and 400% of FPL. So big, great changes that'll cover many, many more low-income people in Washington than Charity Care already does. This will be updated in a publication on Washington Law Help, which is a really wonderful website that I use all the time. I send publications to my clients in different languages from it all the time, and Jennifer's going to circulate a list of publications that we're going to refer to a lot in our presentation today. But one really helpful publication is, Can I Get Charity Care Benefits to Pay My Hospital Bill? So these changes will be reflected there when the time comes. Until then, as I tell all my clients, just if you get a bill from a hospital or any provider, call and find out if financial assistance is available. You don't have to use words like charity care, but the protections that hospitals will be required to follow are going way up July 1.
That's awesome. Really great news.
Yeah.
So can I just ask a clarifying question? So this is really just for the hospitals, not for like a regular, your regular doctors, physicians visit that.
Unless it's associated with a hospital. And charity care covers a lot of things. It can cover outpatient care. There are carve-outs to services you receive when you're at a hospital, like radiology is often a carve-out. Physician time can be a carve-out. Labs can be a carve-out, but the bulk of a hospital bill is what will be covered by charity care. Non-hospital debt doesn't have requirements like this at all. But what I tell folks that come to our debt clinic, if you get a bill, any medical bill, call and find out if there's financial assistance. If it's a bill that comes from a non-hospital provider, but it's coincides with a hospital visit you had, and it's one of these carve-outs, apply for charity care as quickly as possible, and then send that charity care award letter to that non-hospital provider is also billing you and say, will you agree to abide by, the hospital found that I am too poor to pay this bill. Will you agree to waive your bill as well? And it can't hurt. It's not, they don't have to, but some will. So, but important to get that charity care award letter first and demonstrate that, look, the hospital's determined that I'm too poor to pay. Will you agree to follow their determination and waive this bill?
That's great. That's great. Great advice. All right.
Julia and Becky, there is a question in the chat about the new charity care is retroactive.
It is not. It is for care received on or after July 1, 2022. So it won't, these new heightened protections won't kick in until July 1, and it's for care received on or after that date.
All right. Was that the last question?
That's the last question in the chat. I will also say, if folks are interested in learning more about the current charity care, Julia came and did a wonderful presentation in November and went into a lot of detail around accessing charity care, and the recording's available. I'll stick the link in the chat, but there's tons of information. It can get really confusing, but there are resources available to help wade through that even before the new changes take effect.
Great. Thank you.
And just in general, the publications on Law Help are a great place to start as well.
All right. That's WashingtonLawHelp.org?
Yes, sorry, WashingtonLawHelp.org.
No, I just wanted to make sure and make sure we have that in there too. All right. Okay, so looking back for collections and credit reports. So technically collections stay on a credit report for I always say 7.5 years because the clock really starts ticking typically about 6 months after the account has gone past due. So 7 years from the date that it did go past due with the original creditor. The time is not extended on how long it will stay on the credit report by making a payment or, saying that, oh yeah, I do owe this debt. And I don't know, Julia, do you want to add anything to that? But, right. Well, I'm gonna hand it over to Julia in terms of suing over a debt.
So as Becky mentioned, there's statute of limitations that apply to when a creditor is still within the time limit to sue to collect the debt. And in Washington, written contracts are subject to a 6-year statute of limitations, oral contracts 3 years, and promissory notes 6 years. So, and as Becky, so the statute of limitations, so when you first miss a payment and that debt goes into default, the creditor has 6 years from the date of default, which is usually around the first missed payment, to sue you, or it's too late to sue you. As Becky mentioned, it can stay in your credit report for a little bit longer, but the time to collect on that debt and a typical consumer debt is 6 years. And after that, it's too late. And if they sue you after that 6-year date, they have violated federal and state law, the Federal Fair Debt Collection Practices Act or the State Washington Collection Agency Act. If you make a payment on the account before that 6-year statute of limitations runs, that can extend the debt, the life of that debt, for another 6 years from the date of that payment. If you make a payment after the 6 years have run, it cannot extend the 6-year statute of limitations. And that would, what we did as a state several years ago is it's an anti-zombie debt bill. That debt cannot come back to life after that first 6 years have ended by your partial payment after the statute of limitations runs. So if you acknowledge the debt in writing, signed by you, that you owe the debt before the statute of limitations runs, that can also extend the statute of limitations another 6 years. If you agree in writing and sign that agreement to make payments on the account before that first year statute of limitations runs, that can extend the debt. But a payment, acknowledgement, or agreement after that first 6 years cannot extend the life of the debt. And the debt collector is violating state and federal law by suing you after that time period. So we're really, when Becky and I talk to clients, we're very interested to know when was the last payment or the date of default, because we want to be careful about advising someone to make a payment before the 6 years runs, or that debt gets life for another 6 years.
So Julia, I just want to clarify because I feel like this is a mind-blowing piece of information. If someone missed a payment and it went into default 5 years and 11 months ago, and they make a payment on it today, it can extend for 6 more years the ability of the creditor to sue them for that debt.
Yes.
Whereas if they waited another month then and did nothing and did not acknowledge the debt, then at that point it could not be extended.
Right. If they make a payment, acknowledge in writing or agree in writing before the 6 years is up, it's going to run another 6 years. After that 6 year big fat deadline, it cannot, you could still choose to make a payment if you wanted to, but it won't extend the life of the debt another 6 years, and you cannot be sued on it. And if you are sued on it, the debt collector violates state and federal law. And
So
this is all also in a publication called Debtors' Rights Dealing with Collection Agencies that we're going to send your way afterwards. from Washington Law Help.
So there are a couple of things in the chat. One is someone noticing trends where the debt is sold to a collector and now showing as a new date. Can you speak to that?
It doesn't gain new life however many times it's transferred. So debt collectors can do things to confuse people, but and maybe Becky, you could talk about the accuracy of that first missed payment date on credit reports. But you know, it would be important for the consumer to try and find out when their last payment was, or when that debt went into default, if you made no payment.
No, sorry, I'm sorry, Julia. You can ask those questions, you know, from a debt collector, and you can ask for that information. Sometimes people will think they've, you know, lost the ability to ask for specifics about a debt, you know, if they didn't respond in the 30 days or whatnot, but that you always have the ability to go back and ask for specifics around the debt without, you know, restarting the statute of limitations on when someone can be sued. So if it is confusing, you know, you're looking at a credit report and it was just sold to a new collection agency and it looks like, you know, the date of the last activity is, you know, much newer than what really is happening. That is something, if you have the original information, you can dispute that information in a credit report and say, no, the date of the last activity, or, you know, when this account went past due was this date, and send that into the credit reporting agency. And the other thing I wanted to say, I told Julia when we were talking about this class that it's a very fine line between, you know, telling someone, you know, you don't have to, you know, it's 6 years and the creditor loses the ability to sue you over the debt for most debts, and, you know, a 1 more year and it comes off the credit report. So I always look at it this way, and this is how I explain it to people, you know, end users, that, you know, we all have this small bucket of money that we have available for us to use towards our bills and our lives. And I can either, you know, pay my bills going forward on time every time and make sure that I'm moving forward in life, or I can throw it backwards towards this old collection debt, you know, and try to get that paid and knocked down. So, and I'm not saying that people shouldn't pay their debts, or I'm not saying don't pay your debts, but at the same time, it's you know, I mean, you really have to weigh it out. Is it what is in my best interest? And as Julia said too, you know, if somebody, you know, once they pass that 6-year mark, or they pass the 7-year mark for it comes off the credit report, if someone super, you know, feels really strongly that they need to pay that bill, they could still potentially, you know, make those payments, and it's not gonna, you know, have a negative impact on them credit wise. It just is money that, you know, they won't have towards something else. Hopefully that makes sense.
And Becky and I will be talking about how to prioritize debt, because definitely with my low-income clients, you know, I want to make sure they're paying rent or mortgage payment first, and food and utility payment before even paying other priority debts. And we'll walk through those later in the presentation. But what all too often happens are very skilled manipulative debt collectors will try and reprioritize someone's debt for them and stress them out about a particular debt that they really shouldn't worry about as much as maintaining, as Becky mentioned, you know, certain payments, housing, car payments, food, utilities. So, and we'll talk about that later.
All right. So just a little bit more on the, you know.
Sorry, Becky.
Oh, I'm sorry. Go ahead.
Sorry to jump in. There are actually a few questions in the chat, and I'm not sure if you want to address those now or if they're things that you're going to be talking about later on. But there's a question about if this includes educational debt, if these timeframes include educational debt.
Well, it depends on, like, so it's, the debt will survive. It may not show on a credit report. I don't know, Julie, if you want to answer that.
And Well, federal student loans have no statute of limitations on collections. They have lots of wonderful workout agreements and discharge options. A far better choice than private loans always, but the trade-off is the federal government has vast collection powers that include administrative wage garnishments, grabbing your tax refund, and there is no statute of limitations on that debt. Private loans, student loans, do have statute of limitations, but they're not required to provide any discharge or repayment options like federal student loans. So, and that's also a really terrific website that I use all the time is www.studentloanborrowerassistance.org. And it's sort of the A to Z of student loans, how to find out what you've got, what are the best types of loans to get, and what happens if you hit trouble and can't make payments, lose your job, become disabled, and it's supported by the National Consumer Law Center. I use it all the time. I give it to clients, and it's translated into different languages, but again, it's www.studentloanborrowerassistance.org.
I put this in the chat, but we're working on confirming a workshop on student loan debt for later this year because it is an entire other conversation.
Yeah.
And here in King County, and I believe they serve the state, Sense is an organization that does a lot of work around student loans and among other things, but specifically around student loans. All right, there's another question about type of debt, so I'm going to address that one next. What about real estate secured debt? Does a second mortgage lien expire after 6 years of no payment?
No. So if it's a mortgage, if it's attached to the home, it would not expire. That would be a lien against the home.
Okay, and then there are a couple of questions regarding communications with debt collectors. So if a representative makes the contact with the creditor, does that constitute an actionable contact to extend the statute of limitations? So I think the question might be if like one of us were to contact the creditor, would that extend the statute of limitations on a debt?
I think it's got to be an agreement or a promise to pay in writing signed by the debtor.
Writing, yeah.
Go ahead. Sorry, Becky.
No, I'm sorry, Julia. I'm sorry. I was just gonna say, so if I call a debt collector, I don't have the power unless maybe they gave me power of attorney or something, but I don't have the power to, make any kind of agreement with that debt collector or, do anything. I'm not signing anything for that client or, making any agreement or contract for that client. I mean, that would be between the client and the debt collector. They would have to do that in order to, create a re-aging situation where it's going to be, the clock's going to start ticking again.
I do think for folks that are working with clients with debts and collections, though, that it's a good practice not to ever confirm that the debt belongs to your client. I mean, if you are helping support someone figuring out their debts, really being mindful about calling and asking information and not providing any information. That's I think a good line to stay clear of, being aware of sort of what your role is and not wanting to do harm to someone.
And that can be really difficult, because most debt collectors want as much information up front as possible. They want to verify the person's name, their date of birth, their address, their telephone number. So they're going to be really pushing to get any information like that. And then to be able to disclose the information about the debt to a third party is another hurdle. So it's really not the easiest situation to be in. And as Jennifer said, you know, you do have to be careful. Just even in advice that you give to people, we've had someone that was advised to just go ahead and dispute everything that was in collections on their credit report. And the end result was that they were sued over the debts, because that, you know, the credit reporting agencies then contact the creditor, who then, or the collection agency, who then says, oh, well, this person wants to, you know, clean up their credit report, so now's a good time. So they were sued over the debt. Their bank account was garnished, and it just had a horrible ripple effect. So you really can do a lot of damage, you know, and not on purpose, obviously, but if, you know, you're just not sure what to do. So like Julia's saying, you know, going to WashingtonLawHelp.org and, you know, referring people to those publications, or even just reviewing those publications yourself, or, you know, asking questions from experts, you know, like Julia, and you know, picking their brain about, you know, what's the best way to approach this.
And I would say I refer a lot of folks to American Financial Solutions to go over the credit report with a professional who can tell you what is still live debt, what should be prioritized, what's too late to sue on. Credit reports can be very confusing. So, and Becky and her colleagues are really good at helping my clients read their report and know what you should and shouldn't dispute if there's an error on there. So I'm just shouting back out to you, Becky.
Okay, I think there's one last question here. Can debt collectors continue to contact a debtor after the statute of limitations?
Yes, but they cannot sue you. And really important to know when that statute of limitations expires, so you don't you know, if you make a payment, which is your choice to do after the statute of limitations expired, it will not extend the statute of limitations. But they cannot sue you, and if they do, they violate federal and state law.
Great. And actually, there is one more question about type of debt, and that is about child support, especially in arrears. Is there a percentage or maximum that can be collected?
I believe it's up to 50%, but what you should do is look at what money cannot be taken to pay off a debt on Washington Law Help. And there may also be child support publications in the family law section of Washington Law Help.
Okay, and I'm sorry, another question just came in. What if they sent to a new debt collector? But I think what Julia and Becky have said is it's important to work with the consumer to understand when the last payment was made or when the default happened. So selling the debt to a new debt collector does not restart that statute of limitations.
And as Becky mentioned, you can ask the debt collector when the last payment is if you suspect that they're not giving you an accurate date. Check your credit report. And maybe, Becky, you have other ways to try and verify when that payment was made, your own records.
Or even the original creditor, if you can reach back out to the original creditor, if you know who it is. Sometimes people don't know who the original creditor is, but if you can figure out who it is and the collection agency is telling you, which if they're not telling you who the original creditor is, I mean, that's a pretty big red flag. Why am I going to pay a debt when you can't even prove to me that I owe it? But yeah, going back to the original creditor to find out when an account went past due, you know, or when the last payment was made on the account, and, you know, counting out basically 30 days from that last payment and starting the clock. And that's it. It's a good practice, you know, if you have the opportunity to work with people over a period of time, or even just as you're working with them, to, you know, encourage people to keep copies of their credit reports, so that as things change over the years, they can look back at old files and go, yeah, you know, this was, or this, you know, one says that it started in, you know, 2020, but now this one says 2022. So obviously, you know, somebody's misreporting information.
Okay, so the court process for debt collection, that debt, as we've talked about, goes to collections, and the creditor has that, in general, that 6-year time period to sue to try and collect. In terms of the timeline of a lawsuit, the debt collector has to have you personally served with the lawsuit, and it's got to be filed first. Once you're personally served with the lawsuit, the consumer has 20 days to answer a lawsuit, and just flagging another publication, How to Answer a Lawsuit for Debt Collection, is another law help hub, really terrific, walks you through it, lists lots of different defenses in a checkbox form, and explains how to respond to a lawsuit. In general, so you have 20 days to respond. You can formally answer a lawsuit, which means you're asserting defenses you have. And there are times, and I'd encourage folks to call CLEAR, our statewide intake line, and I'll talk about how to get through to CLEAR at the end. But there may be instances where all you want to file is something called a notice of appearance, and you'd want to do that in 20 days. And that's really just saying to the court and the debt collector, I'm here, I want everything sent to this address. And from after that, you will get notice of the legal proceedings, but you're not formally answering it. So the debt collector's next step would be to move to get a default judgment with notice to the consumer. But it just allows the consumer, if they don't have defenses to the lawsuit, to get apprised of what's going on in the court case. Again, this is explained, and the reasons for answering and or filing a notice of appearance are in that really great publication. So if you don't respond at all, and unfortunately, many judgments that debt collectors get are default judgments, meaning no one has showed up and manifested a defense to the lawsuit, and they get everything they're asking for in a judgment. That judgment's going to be entered at 9% interest. And judgments are good for 10 years and then renewable for another 10. And it's accruing at 9% interest, which can really send the amount of that judgment high quickly. After they get a judgment, a creditor has a right to summon you back to court to something called supplemental proceedings. And we do have a publication about supplemental proceedings on Washington Law Help. You'd come back to court, really important to show up at supplemental proceedings. If you don't show up, a bench warrant can issue, as long as it's not for medical debt. And you'd be put under oath, and you have to tell the debt collector where you bank or where you work, what assets you have, and they're entitled to find out to pay themselves back on their judgment. Instead of summoning you back to court, the debt collector might send you paperwork by mail to tell them where you bank, what's your bank account number, where you work. Again, folks should call CLEAR to get legal assistance. We can help people fill that information out. And then the most typical ways a debt collector will collect on their judgment is through the garnishment process. And wage or bank garnishment can happen. And garnishment of wages mean what they would do is get a court order from the court, and much of debt collection in Washington State is happening in district courts. So they get a court order that would be sent to your employer, and the employer will then take a part of every check if they're allowed to. A certain amount of money is protected from garnishment, and that's in our fabulous publication, What Money Can't Be Taken to Pay Off a Debt. But in Washington, for consumer debt, the greater of 80% of your net disposable debt, or 35 times the state minimum wage, is protected from garnishment. And again, this can get confusing, so I'll refer you to the publication. And the employer will fill out a form and let the court and the debtor and the debt collector know what, if anything, can be taken for 60 days from the date of that court order. So wage garnishment has to be renewed every 60 days. They get to charge attorney's fees. Really important to contact CLEAR or a lawyer to see if you can help prevent that wage garnishment from happening. You do get notice of a wage garnishment. With a bank garnishment, you do not get notice because we'd all run to the bank and take out our money. There is money that automatically cannot be taken in a bank account. Again, this is covered in that publication. Benefits like SSI, SSDI, there are a whole list of benefits that can't be taken in that publication, meaning the bank will automatically tell the debt collector to buzz off if they get a court order instructing them to seize part of a bank account. The bank looks in your account and says, nope, they're on SSDI. We can see this direct deposit. You can't get anything. In addition to those automatic federal benefits, as of 2 legislative sessions ago, $1,000 of cash is protected in a bank account for the collection of consumer debt. This is all covered in the pub, but it's $1,000 of a $2,000 cash exemption. So the bank should automatically protect $1,000 minimum, and then the debtor needs to claim the other 1,000 through the exemption claim process. So we wished all 2,000 would have been protected, but that didn't happen. 1,000 is protected, and you have a right to claim another 1,000. And there are other benefits that go in a bank account that that are protectable using the exemption claim process, but that aren't automatically protected. Really important. That publication is so important, and knowing your rights and pretty much acting within 21 days of that bank account freezing. You want to act very quickly, because after that window, it's between 21 and 28 days, which can also be confusing, but after that window, you can't claim that money back, and the debt collector can take whatever they got. So debt collectors can also place a lien against real property. So a judgment is an automatic lien on real property. And I'm not that process and that topic, we could talk for a full day on. So I'll leave it at that.
Julia, there's a couple of questions. Can a collector garnish a bank account if you are self-employed?
Yes.
Okay.
I believe any account with your name on it is vulnerable. I would contact an attorney as soon as possible to see if that corporate form matters, but any account with your name on it, I think, could be vulnerable.
Okay. And then how have court orders or proceedings been affected by the pandemic?
Small claims court is significantly delayed. It may be 6 to 9 months before a case is heard after filing. District court and superior court are also backed up, but
but it sounds like the process is the same. It's taking longer to get through.
Yes.
And another question, are IRA accounts subject to garnishment?
I would check. I don't know offhand, but check the publication, what money cannot be taken to pay off a debt. I think most pensions are exempt,
Most.
but not automatically so.
had a question too, and I forgot what it was now. Oh, I was just gonna say, so I don't know if you have any words of wisdom, Julia, about people who, because we get a lot of people who say they've never even received any notice. They never received a summons. They had no idea they were sued. And now it's after the fact and the creditor has a judgment. Any thoughts on that?
Contact a lawyer as soon as possible. You need to be served. When folks come to our debt clinic in King County, we're going to pull up the court file and look at the very critical document called the Declaration of Service to see where the debt collectors say they served the debtor. Or if they had trouble serving them, is that documented? Did they get a motion to serve by mail? So we want to know who they say they served and when. Is it the right person? If they say you, the debtor, were served, are they describing you? Is this your address? Did you live at this address on that day and time? Bad service can happen, and we know it can happen. So you want to know who they say they served, and if you were not properly served, that can be a basis to vacate the judgment. You'd be entitled to get money back that has been taken to date, but you would also, you'd be put back in the status of having to fight the lawsuit. And it can get complicated, but we would say call immediately when you find out to see if there's a good reason, and they're listed out in some court rules, a good reason, a valid reason to try and vacate the judgment.
Great, thank you.
Yeah.
Okay, so as we were talking about earlier, making that decision about repaying debts that are in collections. There is kind of a process to that I think most of us go through. First of all, looking at the type of debt that someone owes, and not just debt, but their normal, monthly expenses, their rent, their housing, or mortgage. If they, have to make a car payment because they need it to get back and forth to work, or childcare payments or things like that. So really listing out the monthly expenses that they have. Again, not just those things in a credit report, but everything, and putting those in a list. What's my priority here? What are the things that I have to live, to be able to go to work, to be able to eat, and then looking at those debts that are on a credit report, or in collections. Really, again, that priority list, and thinking about what are the dates, and if I'm looking at things that are on my credit report, how soon are they coming off my credit report, or how long are they remaining on my credit report, however you want to look at it. And maybe putting those in order, from the, most recently added to the longest ago, the oldest things that are on my credit report. But also, what are the types of debts that are on the credit report? We look at things that might be a higher priority. Perhaps there's a, past due rent that somebody owes, and that's preventing them from being able to rent another house or an apartment. So that might be a higher priority debt, or, debts that are owed to for child support, or debts that are owed, to the IRS, or things like that, or legal fee obligations. That might, again, take a higher priority. So those are the again, and just thinking about what it is, how do we keep someone moving forward, and, avoiding additional issues when it comes to the collection debt, and when it comes to their normal everyday lives and being successful. Julia, did you want
to? You mean on other considerations on prioritizing?
Yeah, or anything.
Yeah.
Here in this.
Yeah, again, with our clients, there's really rarely any extra money. So we're helping them prioritize debts, and maybe figuring out which ones don't need to be paid right now. Rent, mortgage payment, car payment, utilities, car insurance. Don't want to forget that. Not having car insurance can land so many clients on an immediate financial jeopardy, and often leading to bankruptcy if they cause an accident. So look at that publication, Prioritizing Debt. And there are times when bankruptcy would be a terrific option for someone if the bite that's taken out of your wages is going to prevent you from being able to pay rent or meet other obligations. Essentially, if you've got, something that can be taken and that's going to really impair your ability to pay priority debts, bankruptcy might be a great way out. And folks, Northwest Justice Project, we've stood up an internal bankruptcy team. They're closed right now because they're quite swamped. I believe Northwest Consumer Law Center is still doing sliding scale bankruptcies. Often, so you can file bankruptcy once every 8 years. And between bankruptcies, really important to have, if you declare bankruptcy, important to have health insurance and car insurance, because those are the two ways you can accrue a lot of debt in a jiffy. If that debt is threatening your home, again, if there's an asset that's threatened, you want to talk to a bankruptcy attorney and figure out if bankruptcy is the right option for you. If someone comes to me with $10,000 of hospital debt and $50,000 of credit card debt, and they're earning wages above what's protected from wage garnishment, that person might be a great candidate for bankruptcy. Don't worry about getting, we want to know the global picture of what kind of live debt, again, debt within that 6-year window is in that consumer's world, and to try and reduce the stress, reduce that burden, and protect their wages or asset. Other folks who can get really stressed out, there might be someone who's calling and their only income is SSI or SSDI, that is automatically protected and can't be taken. And they can send the letters as we describe how to do in the Dealing with Debt Collectors publications. But, that's not going to necessarily stop the process of debt collection or suing. And that might be incredibly stressful for seniors, say, in particular. Even though nothing can be taken, maybe bankruptcy in certain situations like that are warranted to remove that stress of debt collection, which can be really burdensome for people who are vulnerable.
I wanted to say about that too. I think, as we think about what our role can be if we are a case manager or financial coach, but we're not, a credit counselor or an attorney. From my perspective, I think one of the biggest hurdles for folks is even just looking at their credit report, right? Like the logistical and the emotional barriers around like pulling the credit report and looking at it. And so thinking about like, what can our role be? I think number one is helping folks with that process. What I have seen over and over again is that people would come and say, I think I need to file for bankruptcy. And I would say about 80% of the time, their credit report was not actually as bad as they thought it was. They just hadn't even seen their credit report. And they were thinking like, well, I'm getting all these calls, so I must need to file for bankruptcy. So I think, helping people see their credit report, and then, referring out to the professionals that can really help dig in if there is a lot going on the credit report. Anyone can sit with someone and walk them through that process and start looking at it. But then knowing, when things get complicated, American Financial Solutions and NJP exist to help with those really complex, challenging situations. And that's when to refer folks out. So I think, thinking about what are our different roles in working with these folks.
That's a great point. I also want to add one thing. A lot of people think, oh, bankruptcy is terrible. It's going to ruin my credit. Well, a lot of times my client's credit is already really not good. And frankly, a bankruptcy is going to help clear it up much faster. They'll, and it puts them in a different category. It's not the mark, the negative mark, or people assume that it's going to be way worse than having bad credit currently. And in fact, oftentimes it's the opposite.
It's a step, someone has decided that they've made a decision about their finances rather than leaving it in a situation where they just have, multiple unpaid debts or collection accounts. Bankruptcy is actually, it's a financial decision. And it is viewed differently as opposed to just uncollected debt sitting on a credit report. It really can be a huge game changer for people, especially to restart.
Okay, so there's a couple of questions in the chat. The first is, any thoughts on what chapter of bankruptcy to file?
Depends on, I think a 13 is considered a wage earners type of bankruptcy, but it's really important to talk with the bankruptcy attorney to assess that. It's generally for clients, it's a 7 or a 13.
All right, and sometimes it's challenging to find the debt origination after it's been purchased multiple times. Any suggestions?
Really, if it's been purchased by a debt collector, that debt collector, you shouldn't have, okay, so typically you should have no problem finding out who the original, who you originally owe the debt to, because that debt collector needs to have that information. And they need to be able to provide that to you. So asking them for that information is where it should come from. And if they can't provide that information, there's no way they can validate the debt. And at that point, I'm not going to pay a debt that someone can't prove to me that I owe.
When there's a type of debt collector called a debt buyer, and that debt may have been bought and sold many times before getting to that debt buyer. So if someone comes to our debt clinic and they're being sued by a debt buyer, they're the plaintiff and they've got to show they properly own that debt and have to show us an unbroken chain of assignments from original creditor to the plaintiff in that lawsuit, the debt buyer that's suing them. And we're going to ask for that in litigation, and the consumer has a right to get that information as well. They have to prove to the court that they properly own the debt and that this debtor is the correct debtor to be suing for this debt. And if they can't show an unbroken chain of assignment, that lawsuit's going to fail.
Okay.
One more thing I just wanted to mention is either Julie or Becky, one of you mentioned driver's license. So when you're thinking about prioritizing debt, thinking about like what is harming someone's current situation that could be addressed. And I just want to share that Express Credit Union has a suspended driver's license loan program for folks that have either tickets or, for no insurance or for no license in collections. This loan program will pay that off for them, and then it will help them build credit as they repay the loan to the credit union. And so I just want to share that link because that's for anybody in Washington State. Their only office is in South Seattle, but they serve anyone in Washington. So it's a great resource for folks that are dealing with multiple debts and specifically debts that might affect their driver's license.
All right. That's great. That is a great resource. Okay, so I just, just thinking about repaying the debts, and I know we've kind of talked a lot about this as we've gone through today. There are a few things that are kind of red flags and things to think about, avoid paying, times to avoid paying collections. So first of all, if they cannot provide any kind of verification that you actually owe the debt, then don't do it. And I know that seems kind of silly, but sometimes people get really frustrated and scared and nervous. And so they're like, you know what, I just paid it because I wanted to get it out of my hair and I didn't want to have to worry about it. They're demanding payment by Western Union. that's often a fraudulent situation. So the person, again, doesn't actually owe the debt, and it's just harder to track down someone on the other side of that Western Union once you realize that, I shouldn't have paid them. If they're demanding a payment by check over the phone, particularly if they called you, I honestly don't recommend that anybody give a debt collector their checking account information. I think that is a huge red flag and a big reason to be very wary that, you might end up with debits from your account that you weren't expecting. Again, if you don't owe the debt, seems very self-explanatory, but people do it. And even if you're just not sure that you owe the debt, if there's a doubt that you owe this debt, then that's not the time to be paying it. That debt collector needs to be able to show you that you do, without beyond a shadow of a doubt, owe this debt. And then finally, thinking about it in terms of priorities, like we were talking about before, I have this pot of money. Where is the best place for me to put this money to improve my financial situation? Is it to pay this old, collection debt, or is it to make sure that all of my important things going forward are paid on time? So, the best allocation of my funds. I don't, Julia, did you want to add anything else?
No, I agree. And we're going to talk about this, but you have a right to demand verification of that debt to find out more about it, who the original creditor is, what's been added to the original debt. And you have a right to get that information. We have sample letters demanding that verification in the Dealing with Debt Collectors publication on Washington Law Help.
That's perfect. And I want to say too, I'm going to flip that right now to the Fair Debt Collections Practices Act, which that is part of too. There's kind of a fine line, and I'm talking from my experience in working with people who have worked with other people who didn't quite know how to deal with collections, and who, thought they were giving great advice. But one of the things that you don't want to do is if you know that you owe the debt, and again, you want to dispute it, and you're asking for, verification because you think that they're not going to be able, you think that they're not going to be able to send you the debt, but you already do know that you owe it. That's usually not the time to ask for the verification of the debt, because now they know, again, that you're looking at this information and you're, trying to maybe get out of paying this information, and you're kind of sending up flags that say, hey, now is a good time to contact me, and, take action. I don't know if that made sense, what I just said, but hopefully it did. Don't use it frivolously. That's what I'm saying. So, if you know you owe the debt, don't dispute it, or, say, prove to me that I owe this debt, unless there's some major outstanding issue that they're not going to be able to prove it. Okay.
And as Becky mentioned, there's a federal law called the Fair Debt Collection Practices Act. It covers the collection of debt, whether it's owed or not. This act was enacted by Congress to regulate the process of debt collection and treat consumers with fairness and respect, even if they owe the debt. And collection agencies have to abide by this law. And the law outlines consumers' right to dispute overdue bills placed with collection agencies, to complain about debt collectors. I mean, there are prohibited practices on what debt collectors can and can't do in the practice of collecting debt. They can't be unfair, abusive, or deceptive in the collection of debt. And many of these protections are also mirrored in state law, as I mentioned, under the Washington Collection Agency Act. And both really govern, they can't call you between certain hours, too late in the evening or too early in the morning. They can't contact you more than three times in a week. There are limits, and they can't let other parties know about your debt. There used to be sort of bad debt lists, or they can't call your neighbor and say, Becky owes us money. Will you go knock on the door and tell her that, we're trying to reach her? So publicizing to other people is not allowed. They can't threaten you to do things that they're not legally able to do, like take protected money or money that's protected from garnishment, or throw you in jail or prosecute you. They must contact you in writing. And if they call you first, you want to insist they follow up in writing. And the notification of that debt has to include the amount of the debt, the name of the original creditor, and a disclosure stating you have 30 days to dispute the debt. And if you do dispute the debt, they've got to send you verification of the debt's validity before they move on in the collection process.
And I apologize. I didn't mean to advance the screen and I didn't want to go back.
Oh, no, that's good.
And Becky and Julia, I just want to let you know we have 15 minutes left.
No. Okay. And I think this is what kind of what Julia was talking about. And Julia, I'll go ahead, please.
Yeah. So there's a sample letter in the publication dealing with debt collectors. Sorry to be a broken record on it, but I use it all the time. But a letter that someone can use, the consumer can use to stop communication from the debt collector to them. And it would be a great time to let the debt collector know that you have no income or assets and can be taken to pay this debt. Say you're on SSI or SSDI. And the form letters on Law Help have that ability to communicate that as well. But you'd be basically saying, please stop communicating with me, and citing the Fair Debt Collection Practices Act, which is in those sample letters. And the only reason they can contact you after that lawfully is to tell you they're going to stop collecting or to file a lawsuit in court. So, and if they do contact you, and it's not for one of those reasons, after you've sent the cease and desist letter, and we recommend communicating with debt collectors by certified mail return receipt requested, so you get proof of when they receive your letter. If they contact you after you send them a cease and desist letter, and it's not for one of the acceptable exceptions, they have violated federal law, and you should contact an attorney. So there are also prohibited practices, as I mentioned, are also listed in our Washington Collection Agency Act. And violations of the prohibited practices under our state law are also a violation of our state Consumer Protection Act. So really strong enforcement and good consumer collection statutes protecting the way debt collectors are allowed to collect from, or to try to collect debts, even when they're owed.
It's very good. Just some of the documenting, the collection calls, if people are receiving collection calls, if they feel like someone's harassing them, even just as good practice, and I'm kind of jumping over here, but just documenting contacts, documenting time of day, how many times that they've contacted you. If you have information, like the telephone number that they're calling from, or their name might not be the real person's name, but whatever name they're using, a summary of what they're discussing or what was discussed. Just keeping documentation of that, if something does happen or you do need to make a complaint, you have records of that information. As Julia's been talking about today too, admitting that that debt is yours, is putting that information or putting that in writing, that this is mine, and agreeing to that can restart that statute of limitations. So avoiding that. And I always tell people, avoid arguing with the debt collector. That's part of the shtick, is to, get people emotional and spun up. And so they're like, okay, well, I'm just going to ask my friend Jennifer if I can borrow some money to pay this off, or I'll just go get a payday loan or whatever. And it makes the situation worse. So if you start to feel, if someone starts to feel, frustrated or anxious as they're talking, just get off the phone, hang up. They're not your friend. It's okay to get out of there. And then.
Quick question, if the debt was incurred in a different state, but the client lives in Washington, is it the laws in the state in which the debt originated? Do those laws supersede?
No. No. If they're collecting from a Washington consumer, that collector is subject to Washington collection laws. But it's the Federal Fair Debt Collection Practices Act is a federal law governing everywhere, but you're also subject to our state laws in garnishment of wages and bank accounts.
And I know we talked a lot about the illegal collection practices already. We did talk about that. Julie, were you going to say something else? Sorry. I didn't know if I just cut you off.
No. Nope.
Are consumers able to continue getting more frequent free credit reports? That I know that changed during the pandemic. Is that continuing?
They have gone back to the one free credit report from each bureau every 12 months at this point.
And the way to get that free credit report is to go to www.annualcreditreport.com.
That's right. Some of them, Equifax, Experian, and TransUnion, I know, I think it's Experian, does do a free credit report with a FICO credit score that someone can get, once a month. It's updated once a month. And again, that's free and it's a good source. But I don't know that the other two have a free, like monthly option as well yet. We'll see what happens.
That was Experian, Becky?
Yeah, I'm pretty sure. Yeah, it's Experian.
Great. That's good to know. So reporting Fdcpi violations, the Federal Trade Commission would be a great place to complain to. The Federal Consumer Financial Protection Bureau is also a wonderful place to report to. Our State Attorney General's office. The Department of Licensing has something called the Collection Agency Review Board that regulates practices of collection agencies. Another place to complain about collection agency conduct that violates our state or federal law. And, definitely, if possible, get legal assistance to help figure out what rights you have and what your remedies are. And as Becky has mentioned, really good idea to keep proof of the debt in your communications, papers, mailings, notes of your conversations with a debt collector. Keep that all in one place. It can be, really valuable information when you're asserting your rights.
So, just to sum up kind of what we've gone over today, understanding that for the person who's dealing with a debt collector, understanding their own finances and being able to go through, look at their, current bills that they're dealing with, take a look at what might be on their credit report, and prioritize those, and don't let that, debt collector be the one who pushes you to pay something that is not a priority. Look at, what are the repayment options, what are the repayment plans, what are your choices, and even thinking about bankruptcy, as we said, that could be kind of a good restart button for someone if they are overwhelmed with a lot of debt and they are in danger of having wages garnished and losing income that way, especially when they don't have a lot of income coming in. Know your rights when you're dealing with debt collectors. What can they do and what can't they do? And what are the options that you have to protect yourself? And that could, be looking at the publications that we're sending out today, but also reaching out to an attorney to find out, okay, can they do this? And if they can do this, what is my responsibility and what can I do to try to circumvent this? And how do I answer if I received a garnishment? If I received a what's the word, Julia? I got my Summons, there we go, sorry.
Got it.
You got a summons, you know, how do I answer that? What do I say? What, you know, what are my choices for the defenses? And again, the publications can help with that too, but it might be worth, you know, contacting an attorney to get more help. And the same thing that we just were talking about, you know, who to contact if something goes wrong. I'd look at our state resources first. I think that, you know, the Federal Trade Commission is great. The CFPB is great. But they aren't going to really do anything, you know, for you specifically or us specifically as an individual. I mean, every once in a while, you know, something will happen, but the state resources that we have is really the place to go and who to turn to. And
I want to piggyback on that, Becky. The also, what I tell clients, I know the mail doesn't bring a lot of happy news, but really important to check mail regularly, like daily, because your rights fly out the window if you don't know what's going on. And there's just so much less I can do if someone receives something important, but the window to act, like, you know, the 20 days has passed, or if they've been defaulted, when I could help them respond to a lawsuit and assert their defenses, or whatever it may be. You don't want to miss out on really important rights because you kind of bury your head in the sand and don't want to look at the mail, but just critically important to check mail regularly. And I totally agree about, you know, the state resources on complaints. It does help, you know, the more all of those places get complaints, then they might see a rash of, you know, 10, 20, 50 complaints about the same debt collector. And it might spur these regulators to do something if they see, wow, this appears like a lot of people are getting harmed right now. Let's take a deeper look. So that's how your complaints can be beneficial too. For legal resources and information, I put our Northwest Justice Project's website. There are different numbers to call for help with foreclosure if you own a home, or eviction prevention. So you can start at our homepage. We do run a remote debt collection defense clinic in King County on Tuesdays, and folks can call our main number 206-464-1519 to get screened any day of the week. And then on the following Tuesday, if the issue can wait that long, if it's more urgent, you might get help sooner, but you'll be put in line for our next debt clinic between 1 and 3 on Tuesdays for advice and counsel. And outside of King County, folks can call our statewide clear intake line at that number listed Monday through Friday, 9:15 to 12:15. There's also an online intake method for NJP services, and folks can fill out an online form. Washington Law Help, I put the website in there. King County Bar Association's Debt and Bankruptcy Clinic for folks in King County is really terrific. They can help folks who are over income for our services or who are undocumented. And in many situations, we're not able to provide legal advice to folks who are undocumented. We can provide legal information, but I can send those folks to get legal advice from terrific. That clinic is staffed by bankruptcy attorneys, and they get debt. Northwest Consumer Law Center, their website is here. They do low fee and in some cases no fee representation in many different types of consumer cases and bankruptcy as well. So they're another terrific resource for folks.
That's a great list of resources. That's awesome. Okay, well, we made it. All the way through. Thank you everybody for being here. I know it's a lot of information that we went through today, even just starting with the new medical debt, you know, information. That was great too. So I don't know if there's any remaining questions in our last 2 minutes here.
Thank you, Becky and Julia, for your time. Let's give them a round of applause because they covered a ton of information. So thank you so much. And thank you everyone for joining us and staying on. And remember, our next workshop will be happening June 21st on cryptocurrency and digital wallets. So if that is something you feel like you would like to learn more about, I will send out that link in the email. I've been diligently noting down all of the publications Julia has mentioned, and we'll be sending that out in the next day or two. So you'll get links to all of that information. So thank you, Becky. Thank you, Julia. And
Thanks for having us.
Yes.
yes, and everyone have a great afternoon. Thank you.